Hello, everyone, and welcome to today's program. No more doggies in the window. New California animal laws and regulations for 2026. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Ryan Gordon. Ryan is the co-founder and co-director of Advancing Law for Animals, where he focuses on impact litigation on behalf of animals. He previously served as general counsel to Beagle Freedom Project and has worked with the Animal Legal Defense Fund and the Non-Human Rights Project. His work has been featured in the New York Times, The Guardian, Science Magazine, and USA Today, among other outlets. We can't wait to hear what he has to share with us today, so I'm going to turn it over to him.
Thank you for the introduction. Much appreciated. I'm going to start a PowerPoint to go through what is new for 2026. Give me one moment to do the share screen here. All right. So hopefully everyone can see that. So,
Um, Ryan, it
oh,
looks like we're actually probably slide six
yeah,
or seven right
hold
now,
on.
if we
Let me
can.
fix this. One second. Sorry. Thank you. Okay. All right. Problem corrected.
If you could, when you can, pull up
Yeah,
the
I have.
slide.
There we
All right,
go. Good. I think everyone.
great.
Okay, great. Okay. So we're going to talk about new 2026 laws in California for companion animals. My organization generally focuses on factory farm animals and animals in laboratories, but today we're just focusing on companion animals. And there are several new laws in 2026, mainly focused on puppy mills, which we're going to get into in a moment. So, all right. I want to talk, before I get into some of the new laws, I want to talk about puppy mills. Many of you probably know what puppy mills are. They are basically high intensity breeding operations that turn out typically purebred dogs for profit. They are very common. Well, they are mostly placed in Missouri is typically the state named as having the most puppy mills. Pennsylvania has a lot. West Virginia also has a lot. But there many thousands of animals, often or hundreds of animals in a mill, and they are in terrible conditions. And the animals that are produced from these operations are often sick. So it's a problem because you can imagine a family adopts a dog, they have kids, they bond with the dog, and the dog very quickly becomes very sick. They spend thousands of dollars to help the animal. And then, despite their efforts, shortly thereafter, the animal often dies. So these families often pay thousands of dollars for a heartbreak. So, puppy mills, I'll just go over some stats in a moment. These are from Humane World, which is a very reputable nonprofit. They estimate that there's about 10,000 puppy mills in the US, about 500,000 breeding dogs, and 2.6 million puppies sold annually from puppy mills. So it is a lot of animals. Next slide. So California has had puppies from puppy mills and other animals from other mill cats or sometimes bred in those conditions uh, permeate the state for quite some time. And the first efforts to combat it were in 2017. So this is I'll get into the new laws in a moment, but I want to give some background first. In 2017, California passed AB 485, which basically ended retail pet stores that were, very ubiquitous for most of us in a pre-digital world. I remember going to the mall growing up. I grew up outside of Philadelphia, and there were pet stores in both the malls near my house. They always had new puppies in them, and now looking back, those puppies were probably, bred in some confined operation out in the middle of the state. But California 485, it barred pet stores, or I'm sorry, AB 485 passed in 2017, barred pet stores from selling dogs and cats and rabbits unless they came from a shelter or a nonprofit rescue group. It didn't go into effect till 2019, however. But as you can imagine, people that breed these animals for a living and people that, want purebred dogs, there's still a demand for the animals. So The breeders very often would create fake nonprofits to evade this law. They would create a fake nonprofit, transfer their animal to it that they bred in a puppy mill, and then this fake nonprofit would sell it in California and evade the spirit of AB 485. So good start, but it did not do the job. So in 2020, the legislature passed AB 2152, which was aimed at combating that loophole. And this new law in 2020, AB 2152, let me go to the next slide, barred pet stores from selling dogs, cats, and rabbits in their entirety. So it did have an exception, which many of us have probably seen, but it allows rescue groups to showcase adoptable animals at pet stores as long as they don't charge in excess of $500. So many of us that have animals, I'm sure, have gone to, PetSmart on the weekend, and there will be a rescue group there that has, 20 kittens or puppies out or ready for adoption, and you go play with them in a gate they have there or something like that. But so that was AB 2152. However, these laws have not stopped puppy mill dogs from entering California. So this last year in 2025, California passed AB 519, and this is aimed at stopping basically online sales. People often buy dogs on Craigslist, Facebook Marketplace, sites like that, and they're often from puppy mills with the same problems that I described earlier. So AB 519 it's codified in the Health and Safety Code, and it affects brokers. And a broker is based, I'm going to read the definition, but a broker means, which I have on the next page, but I'll go back. A broker means a person or business that sells, arranges, negotiates, or processes either in person or online the sale or transfer of or the sale of dogs, cats, and rabbits bred by another for profit. This includes facilitating the transfer of a dog, cat, or rabbit for profit. So it is a very broad definition, and it's pretty much anyone that has their hands in this transaction who isn't the buyer can be a broker. And I'm going to go back one slide here. So AB 519 targets brokers, and it says that a broker cannot or shall not make available for adoption, sell, or offer for sale a dog under 1 years of age, a cat, or a rabbit. So under any conditions. And this is meant to target online sales. So we'll see how this works. It went into effect this year. This is a new law. There are some exceptions to it, uh, you know, which I will go to. So or the exception to 519. Small breeders, so if you can if you're a small breeder, you can sell up to 3 animals a year, which is interesting because if someone breeds puppies or kittens, the litters are often 5 animals, sometimes 6, especially with kittens. So I don't know what that means if they then have to give away for free the animals in excess of the ones they sell. So if they can sell the first 3 and give the next 2 away, I don't know. But that giving animals away for free presents its own problems, which is why a lot of rescue groups do not do it. So government agencies are also exempt. They run government shelters. They can charge for animals and transfer them at will. Service animals, they get to be sold. Animal rescue groups also get to evade 519 because they are asking for donations, selling their animals, etc. And then nonprofits running youth agricultural programs that are aimed at rearing animals and animal care. Those are the exemptions to 519. But everyone else, a broker cannot, again, online sales, they cannot happen. So that is the first law, and we'll see how it goes. It's in effect now. So moving on. The next law I'd like to discuss is also aimed at targeting puppy mills, and this is AB 506. And it complements the prior law, like I said. It's also codified in the Health and Safety Code, and it requires a a person or pet dealer or business that sells a dog, cat, or rabbit to provide the buyer with written notice of the original source of the dog, cat, or rabbit, records of inoculations and worming treatments, and vet records related to medications and whatnot. So uh, it's a record-keeping law. It makes non-refundable deposits for such animals void as public policy, and the seller has to refund any monies within 30 days of notice. So if these are out-of-state sellers, this might seem like it would be not ha like this law would not have a great deal of teeth. However, it does have some interesting enforcement mechanisms. So it allows suits for a buyer can bring a suit in any court, not only for damages, but also for injunctive relief. And that's important because when you're dealing with animals, many times courts will say uh, that if there's a problem with the animal, you just get damages. You can't get injunctive relief. And this pops up in disputes over ownership with rescue groups and fosters very often. Like if a foster or someone has an animal, the rescue group sometimes has difficulty getting the animal back because legal damages will suffice. So sometimes this is a problem. But this law states injunctive relief is appropriate. It also allows even better for a buyer that is harmed by one of these out-of-state sellers. It also allows a buyer to sue and get their attorney's fees unilaterally. It's one way, so the plaintiff can get their fees. So that those are since this is going to be incumbent upon someone who is harmed by one of these transactions to basically enforce their own rights. These are pretty good. So, and also attorney generals, city attorneys, county attorneys, they can they can all enforce this law as well. So that is the second law I wanted to go over. And oh yes, and it doesn't apply to public animal control agencies or shelters. They do not have to give the documentation about the source of the animal, the record of inoculations, etc. So well, they should, but they're exempt from this law. All right. So the next law that I want to go over is SB 3112. And this is the last puppy law or puppy mill law that was passed this year that went into effect, or last year that went into effect this year. So this is codified in the Food and Agricultural Code, and it so before I get to the substance of it, many states already have requirements that dogs shipped into their boundaries have to give some sort of certification to their Department of Agriculture or whatever they're calling it in that state. California did it before this year. So while California is very often ahead of the game on animal laws, this one it was not. So the law is basically, or this new law, which is SB 312, basically requires anyone shipping an animal, and right, it's just a dog actually, anyone shipping a dog into the state to provide a health certificate to the California Department of Agriculture. This health certificate has a lot of information in it. It has to have the date of their exam, a statement that the exam revealed no disease, parasites, or fungi, a record of their vaccine treatments, tests, and results. They have to show that they have the rabies vaccine within the last 12 months, unless the dog is under 3 months old, then they don't have to. The number and description of the dogs in the shipment and any microchips for the animals. They need to give a verifiable physical address and origin addresses of origin and destination for the animal. They need to give the name, address, and contact information for the vet that saw the animal before it was shipped into the state. And they need to, and this health certificate has to provide the info for the transporter and the buyer, and it has to provide a USDA breeder license, if any. So for the breeder license, a lot of puppy mills are actually regulated by the Animal Welfare Act, which we won't get into today, but they have to have a breeder's license then. So the point of all these requirements, why the sellers or shippers are having to notify the California Department of Agriculture that they've brought animals into the state, is so consumers can uh, can verify their information basically, and then so the consumers can also apprise law enforcement if something is amiss. So this is another record-keeping law, but this is what was passed this year, and hopefully it helps. So again, the three laws affecting puppy mills this year were AB 519, which is that is again to recap, that is the law that says no broker can sell any animals. It's that basically is targeting online sales, stopping online sales, and we'll see how it works. The next one is AB 519. Or I'm sorry, the next one is AB 506, and that law is a record-keeping law that requires the buyer to receive written notice of the source of the animal, the records of inoculations, etc. And it allows suits for injunctive relief and attorney's fees if this is if for violations of the law. And then the third law for puppy mills this year is SB 312, and this is the law that requires the importers to give a certificate to the CDFA, giving a variety of categories of information, so the ultimate buyer knows that everything is on the up and up. So those are the laws for puppy mills this year. We'll see how it goes. I mean, it's a big industry, so I imagine there'll be in the next few years some other law will be passed because these will be someone will find loopholes to them somehow. So, but we'll see how it goes. It's great that they're passing them. So moving on to cats, the next law we want to talk about is AB 867. Now, this was passed in 2025. It is a cat declawing ban. There are a lot of places in the state that already had this ban in well, I shouldn't say a lot, but well-known cities. West Hollywood in 2003 was the first city in California to pass this ban through its local home rule powers, and that has been in effect since. And in 2009, a few other cities banned cat declawing within their jurisdiction. Those cities were LA, San Francisco, Burbank, Beverly Hills, Culver City, and I believe Berkeley. I think that is actually it for the whole state. So, which is great, but if someone wants to get their cat declawed, obviously, and they live in Beverly Hills, they can just, I don't know, drive to Manhattan Beach and do it. It was not foolproof. So California stepped up and banned cat declawing throughout the whole state. So, which is great. So I do want to talk about what cat declawing is for a moment because it's people are somewhat confused about it, I think. It's not removing just the claw. It's basically removing the top phalanx, the third phalanx on what is on their bone structure. So it'd be the equivalent of us removing this part of our hand on every digit. So it's a lot more than just removing the claws. They remove part of their foot very often. So that is pretty cruel for a cat because cats, I mean, I have a cat, I have two dogs. Cats, I mean, scratching is in their nature. It's unfortunate for your furniture, but it is in their nature. And this is a good thing that California did. This is a good welfare law, very much so. And it does have some exceptions, which I'll get into right now. So the exception, I am paraphrasing here, but the procedure can still be performed for a therapeutic purpose. And therapeutic purpose means when it's medically necessary to address an existing or recurring infection, disease, injury, abnormal condition in the claws, nail bed, or toe bone, I don't know what that is, which jeopardizes the feline's health. But a therapeutic purpose does not include cosmetic or aesthetic reasons, or to make it the feline more convenient to keep or handle. So basically, the cat has to be its health has to be put at issue before you can remove its claws. So, which is great. So a violation can lead to revocation of a license, $5,000 fine, and there are some criminal penalties as well. So this is good, and I hope other states follow suit because cat declawing is very cruel to your cats. So I had a cat that was declawed once. We found them. Many people have a story have a cat finds them, I think is the expression, but I had a cat growing up with my parents named Scruffy. It was a Persian cat. Someone declawed him, And he was a great cat, and he still seemed happy. But in hindsight, yeah, it's a shame he didn't have his claws. So hopefully other states follow suit and ban this because this shouldn't be allowed. All right, moving on. So the next law I want to talk about is SB 221, and this is a criminal law. So this law is for to address stalking, basically, and it's meant to conform the California law with the federal stalking law, which makes threatening a victim's pet also a crime. So, and it's a specific intent crime. So, the former law made credible threats to the victim of crime. SB 221 expands the definition of credible threat to include threats to a person's pet, service animal, emotional support animal, or horse made with the intent to place the target victim in reasonable fear for their safety. So uh, it's not more complicated than that. It's if you're stalking someone, don't threaten their pet. So this is on the books now, and it's great because this is a problem whenever there's harassment petitions that I've been involved in. Often an animal is involved, and you need to make sure that animal is safe as well. And this goes a step towards doing that. All right. So the last law I want to talk about is AB 478, and this pivots quite a bit from the other ones. This is called the Found Act. So California has the Emergency Services Act, which allows political subdivisions to provide mutual aid and work with the state during emergencies. This new law, AB 478, was basically passed in response to the fires last year. A lot of people had pets left behind, and they wanted to go back and get them, and that was, as you can imagine, a coordination nightmare. So this new law applies to any household pet. Its pet is written broadly, fish, bird, amphibian, dog, cat, other species of animals. I'm assuming the fires around Malibu, a lot of people have horses there and other sorts of livestock. So this new law applies to all of them, and it requires me summarize. It's a pretty long law, but I'm going to summarize it. So the bill requires municipalities to come up with emergency protocols for declared emergencies like fires, for example. And they need emergency protocols when someone's pet is left behind in an emergency. So these municipalities have to coordinate with the owner, if the owner is going to go back and get the animal, have the owner sign a liability release. And when they do that, they need to determine the best time and method for the owner to retrieve the animal. And I have this on the slide here too as well, but this right of reentry for an owner is not absolute. So they can be told no, but there has to be some protocols in place for an owner to go get their animal when they're left behind in an emergency. So the municipality must also designate a contact person for each area who can respond and provide animal evacuation information to local residents. And I should mention also that this information all needs to be posted online on the municipality's website. So, and then the one that I suppose rescue groups are most happy over is that in this new law, any animals that are found in an emergency have to be held for 30 days without transferring them or euthanasia, because a lot of people after the fires here or other, the floods in Texas last year, whatever it may be, there's often a difficult time of families finding the animal. So they want to allow 30 days for reunification of the families and their animals. So and this law allows for that. And if the animals are transferred to a state facility and not reunified with their families, a rescue group can also take them and just by giving notice, and they'll take them, and that prohibits the state from euthanizing them as long as the rescue group gives notice. So hopefully there's no more natural disasters, but there certainly will be, and hopefully this helps families get reunified with their animals. So those are the new laws this year. I'm just going to do one quick recap. Puppy mill laws are AB 519, that is the main one, and that bars brokers from selling animals anywhere online, and anyway, it's aimed at online, but it bars them from selling them anywhere. And with a few exceptions, small breeders, government agencies, service animals, animal rescue groups, and youth nonprofits. They're not bound by it. But other than that, brokers, no one is selling any dog under a year, or cats or rabbits. So yeah, for profit. And then AB 506 that complements this the AB 519, the prior puppy mill law. AB 506 is it's a record keeping law. It requires the owner, the buyer, to get a statement of the source of the animal, records of vet records and inoculations, and that's about it. And it allows for suits for damages and injunctive relief and attorney's fees. And then the last puppy mill law is SB 312, which requires anyone bringing an animal into the state to tell the California Department of Agriculture they're doing so by giving a certificate having a lot of information on it that I went through earlier, like it's the animal's exams, where the animal's going, the vet, the physical address the animal came from, things of that nature. And then those are the puppy mill ones. The fourth law is AB 867, which is the cat declawing ban that is now statewide. And then the anti-stalking law is SB 221, which now makes it a crime to stalk or to threaten someone's pet while stalking them. And then the last one is the AB 478, which amends the California Emergency Services Act and allows for emergency planning relating to house animals or to companion animals. So that's it. And thank you for your time. And those are all the laws that I have to go over. Looks like there are ones. Let's see if there's any questions. Second. To whom does a consumer lodge a complaint of these various violations? Well, that if you're looking for a puppy mill, there could be several areas. You could do it federally because they might be operating an illegal they might be operating an illegal breeding facility. I mean, it depends where the animal came from, which is the point of all this record keeping. And this is R.H. Lemiranda, I believe, is who posed this question. But yeah, that would depend where the animal came from. You could, one of the laws allows to sue yourself, which with attorney's fees. But I think you'd want to apprise. It would depend on the location of the mill, so that would be context dependent. So, and I hope that answers your question. For example, if it's in Missouri, you can apprise the Missouri Department of Agriculture or the USDA. If they're not licensed, that would fall under maybe that jurisdiction. So, okay. Well, that's the only question, but thank you for your time. And that's all I got.
This concludes today's presentation. Thank you so much, Ryan, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.